we kind of won the battle for ARVs, but we kind of lost the war for, kind of structural change and kind of looking
well,
at
the war's not over.
Yeah.
Yeah.
That's a good point.
We haven't yet won the war.
Sure. What's your 1 minute kind of pitch for why patent law reform is needed in South Africa?
Well, certainly the work I've been involved in has shown that kind of to use the legal system in respect to the current patent framework. It is very labor intensive, it's time consuming, it's costly, it's drug by drug. As you've recognized, we've only been able to do it so far in relation to HIV medicines. That's most likely also because that's where the movement has been. And so the kinds of conditions that you need to be able to operate within the framework as it currently is are not the conditions you're going to have to deal with all other meds. So there's certainly a need for patent law reform. I mean, it makes absolutely no sense, and I think our paper does support this argument. It makes no sense in a country that is quite marginal to global R&D. No disrespect intended to the country, but to have a Patents Act that grants the type of protection that's over and above what is required under international law. So what we need is an act which recognizes that we have certain minimum obligations, but respects that, but doesn't necessarily go further. I think in the end, the act, it won't be as, it will go further than what is required, but there'll be some. The question is how much further does it go? There are a bunch of issues that need to be addressed, whether it's the issue of substantive search and examination, which I think is an important issue, but for me it's not the primary issue. Because ultimately what one wants is one wants access to innovations, and particularly those that, no matter what your patentability criteria are, you want access to those products that would satisfy the most stringent patentability criteria. So a real new breakthrough drug, which the country will have to provide under TRIPS, has to provide patent protection for. You want access to that drug as well. And so for me, it's very much about having compulsory licensing provisions that are easy to use, that deal with royalty rates quite simply and effectively, that recognize a very broad range of grounds upon which you can bring applications. Those are the kinds of provisions that one needs. And I think without those types of provisions, you're not going to be able to kind of get the products to market that need to get there. I don't necessarily envisage countless numbers of compulsory licensing applications in court. I don't think that will be necessary. I think if you have the framework in place, what you will see is a much greater willingness on the part of companies to license, and to license quite swiftly.